Friends, welcome to Simzuu. Let's begin our journey with our motto, knowledge prospers all. Friends, in the last month, I had a throat infection due to some viral sort of a thing they say is going on in Pune. And that's why there was a little bit of a momentary voice loss also. And that's why we didn't make any videos. Okay, all that is cured. So let's begin. Today, friends, we are going to see a new definition as to what is an industrial dispute. Earlier, we have seen what is an industry, who is a workman in detail, and perhaps this video, that is the industrial dispute, might consume 2 episodes. What is an industrial dispute? Let me give you an example. Today morning, I had 2 fights with my wife. Usually there are more, but today there were only 2. Can you say there were 2 industrial disputes in my house? The answer is a simple no, because number one, my house is not an industry, and my fight with my wife cannot be qualified as an industrial dispute. Now, this brings us to the premise of what is a dispute itself, and then we'll see as to what is an industrial dispute. Now, this was answered by Justice Shah in Narendra Kumar Sen case, wherein he said that a dispute is a difference. There's a difference between the union and the management, you and me. A dispute is a difference, but is it an industrial dispute? Industrial dispute has to further qualify into certain things. That is, it excludes number one, all metaphysical and philosophical controversies, and sees that dispute which is in real substance as per definition which is in section 2K of the Industrial Disputes Act. Industrial Disputes Act has definition. Section 2K defines an industrial dispute. The name of the act itself is Industrial Disputes Act. So it's an act to deal with industrial disputes. I'll give you a simple example. Friends, say I have a small industry and my workers, they have a charter of demand, and then they gather and they start giving slogans, हमारी मांगे पूरी करो, हमसे जो टकराएगा मिट्टी में मिल जाएगा, and so on and so forth. Ultimately, I think one at least go and let me discuss with them what are their demands. So I went outside and asked the workers as to what are your demands. I mean, since 3 days you are just shouting, हमारी मांगे पूरी करो. So what are your demands? And as a prudent employer, it's in the fitness of things I address those demands. And the worker said that, come on, go and solve the Kashmir problem. And I was taken aback. Question is, can I solve the question as an employer, solve the Kashmir problem? Is it my duty? And there could be so many such problems. The answer is very simple, that the employer, that is myself, I do not have a solution to it. So the dispute should be such that the employer should be in a position to remedy the dispute. That remedy should be available to me. And this again brings us to the premise as to what is the definition itself. The definition says it's any dispute or difference between employers and employers, employers and workmen, workmen and workmen with respect to employment, non-employment, terms of employment and conditions of labor of any person. This is the definition. Now friends, I just now said it's a dispute or a difference between employers and employers. Both employers, yes, there could be 2 chambers of commerce. They could be fighting amongst themselves for some sort of a thing which is related with labor law, and it could be an industrial dispute. This is pretty easy. We go to the next category, workmen versus workmen. Now, on the one hand is one union and the other hand is another union. So there are 2 unions and both are fighting for a recognition in a specific industry. As you understand, recognition is a concept which is spelled out in the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act 1971, wherein we see that there can only be one union which can be recognized in an industry. And it can be, it's possible that in any industry there could be 4 unions, 5 unions. And it is Diwali time, and then who's to negotiate with the management? And everybody says that I'm in the majority, I'm in the majority. Ultimately, the management or the employer tells them that you are 4 to 5 unions. Go to the industrial court, bring a certificate of recognition. And after that certificate of recognition is brought, the union in whose favor the Honorable Industrial Court passes the recognition order, I am supposed to talk with him, because this recognized union is supposed to be the sole bargaining agent. I cannot talk with anybody else, leaving aside the recognized union. But the answer is, what am I talking? What am I talking basically? What I am talking is, this is a dispute as regards recognition between 2 or 3 unions, and that is why it is a dispute between a group of workmen versus another group of workmen, and that is the definition, workmen versus workmen. And the third category, friends, is very simple. When I was in school and when I was in college, and I used to hear, or in the newspapers also, that in that industry there was some problem. What is that problem? So on the one hand there is a union, and on the other hand there is a management. So friends, we saw 3 categories: employers versus employers, employers versus workmen, which I am going to tell you in detail. And the third is workmen versus workmen with respect to, say, recognition, or there could be so many disputes. But then this is the categorization. The dispute is with respect to what? And the dispute is with respect to employment, non-employment, terms of employment, and conditions of labor of any person. Yes, friends. Now you see, employment. What is employment? The dispute or difference refers to the employment. Employment means there are so many aspects of employment. This refers to matters concerning whether a person should be in service or continuation of their employment. Now you see, think of a situation when there are a bunch of contract workers, they are working for years together and they want to be absorbed as regular workers. So they go to the appropriate government and raise a dispute about abolition of the contract in a specific industry itself. So it is a dispute regarding employment. Then there is the employer, say, refusing to take a probationer on its permanent roles. The employer appoints a probationer. Under the model standing orders, the maximum period is 3 months. I mean the model standing orders. And he continues the probationer for years together. So this is an aspect which deals with the employment of the worker, and which is, of course, an industrial dispute. Now friends, there are so many cases wherein, say, in Bharti Airtel versus Raghavendra, it was held by the Supreme Court that a senior manager who had no power to dismiss any employee, he lacked the power even to hold a disciplinary proceeding, and whether he is a workman or not, whether he is or he is not what we are going to discuss here. Question is it an industrial dispute? And the answer is yes. Then, say, in Dharam Singh versus state of UP, it so happened that a long serving daily wages or ad hoc workers, in India there are daily wage people, employment guarantee schemes, he comes and he is working there for 20 years altogether. Ultimately, court said that, are you not going to absorb these people on your permanent roles? But what is this? This is also an industrial dispute because it pertains to the employment. And then the Telangana High Court in BHEL, paramedical staff regularization case, it held that the paramedical staff went on for working on 6 months contracts for years together. You give him a 6-month contract, then give him an artificial break, again a 6 months contract, then again a break. This continues for years together. So this is regarding employment. And what we have seen in the definition is, it's a dispute or difference with respect to the employment, non-employment, terms of employment and conditions of labor, of which we saw the first one, that is, what is the employment itself. Okay. And of course, not to forget that it's a dispute or a difference between employers and employers, employers and workmen with respect to employment, non-employment and all of those things. Now friends, about the non-employment. What is non-employment? Non-employment means the person goes out of the employment. You are dismissed from your service is non-employment. You are terminated from your service is a species of non-employment. You are discharged from your service is again non-employment. You are compulsorily retired is again non-employment. Now friends, in all of these cases, the person goes out of the service, which of course is an industrial dispute. Now there have been a number of cases, say for example, retrenchment. Somebody is retrenched and he is not given the retrenchment compensation. Retrenchment compensation has to be given before a person is retrenched. That is, there is surplus labor. We are not on the retrenchment point right now, but cases of retrenchment wherein a person goes out of service is a species or an instance of non-employment. And there have been so many cases as far as retrenchment is concerned, whether the retrenchment is legal or illegal. We have already made a detailed video on solitaire tools. The solitaire tools case, those of you all who have not seen it can see that video. Besides, there are so many other cases also. Say principal chief versus Rathina Velu case is there. Then Sharad Mohitkar versus the general manager or refuse. Now see, people are retrenched. And then why do you retrench them? Because there's no work. And the moment you retrench them, after 2 months, you fill in the same post. Then why did you retrench this person? Now this is squarely covered under section 25H of the Industrial Disputes Act. So the issue is re-employment of the retrenched labor. Those labor or those workmen who are retrenched will again go in the court of law stating that or praying to the court that unnecessarily we have been retrenched because some other people are appointed in our place. So this case becomes a case of re-employment of retrenched labor, which of course is an industrial dispute itself. We are on the point of what is an industrial dispute. Now friends, as far as re-employment of retrenched labor is concerned, again there are so many cases. Say for example, management of Barara Cooperative Society versus Pratap Singh, or Bharani Dharan versus Managing Director Tamil Nadu State Transport Corporation. So these are the cases, but ultimately what am I talking? What I am talking is an industrial dispute under section 2K itself, wherein the definition at the cost of repetition, I repeat, it's a dispute or a difference between employers and employers, employers and workmen, workmen and workmen with respect to employment, non-employment, terms of employment and conditions of labor of any person. So friends, taking a conspectus of everything, the definition remains as to what is an industrial dispute in section 2K of the Industrial Disputes Act. And we have seen 2 episodes of this definition. We at Simzuu wanted 3 definitions to be very we were very particular about 3 definitions. One is what is an industry, who is a workman, we had 3 episodes, and what is an industrial dispute, 2 episodes. So in our journey of knowledge prospers all, we will meet you next time with something else. Okay, thank you so much.